little cooler.
This is a proof of life.
Yeah,
That's right.
That might be an exaggeration, so good to be out there.
It's too hot.
You're lucky, right? And then that dark kid voice.
So if, yes, I would say if she's willing to.
Jen and I purposely were working together. I just saw Ryan Shields' hottest video from my building with light. It's gonna reflect all the light.
Like for the rest of the week.
Pretty much.
Yeah.
We're very much of it.
I can't believe
Good afternoon. Last Saturday, tragically, 2 officers from the Orlando Police Department were shot and injured. Our thoughts and prayers are with the 2 officers, their families, and the entire Orlando Police Department at this time. I know it is a difficult time for the agency. I spoke with Chief Smith on Saturday regarding the condition of the officers and wish them a speedy recovery. It is not lost upon me the difficulty of the job that law enforcement engages in every day when they go out to protect and serve our communities. It is a dangerous job and one that we do not take lightly. The individual in this case, Daton Viel, is known to our office. He was serving a probation sentence for trespass from a few years ago. However, he has a criminal history that goes beyond the state of Florida and Orange County. There's a 2019 case out of our office for trespass, for which he was placed on probation for a period of 18 months. And he violated his probation and had a warrant out for that violation since June the 16th of 2023. There is also a fleeing and attempting to elude charge based on a contact that he had with the University of Central Florida Police on June the 30th. And there was a warrant for him out on his arrest since July the 6th in that case. There have been a lot of questions regarding a sexual battery case that he was out on bond for, and I want to talk about that a little bit later, but I also want to bring out the fact that for a aggravated assault, arson, and battery out of Georgia, he had been placed on probation in February of 2022, and that probation had been violated, and he had had a warrant out for him from Georgia since May 10th of this year. There have been a lot of questions regarding why was Mr. Viel out on the street so that this tragic incident that occurred on Saturday could take place. And I want to take this as an opportunity to clear up some misinformation that has been spread, I think originating with the FOP, and use this as an opportunity to educate the community a little bit on the criminal process and what happens when someone is arrested. I first want to take you to the fact that here in Orange County, bond is determined by a bond schedule and by the court. It is not set or determined by the state attorney's office. It is within the discretion of the court to set bond for individuals, and typically that is done based on a bond schedule or by the discretion of the judge based on the specific factors. In this case, Mr. Viel came before the court for initial appearance on March the 27th. He had an initial appearance and the court set bond at $125,000 on April the 14th. Now, $125,000 is not a small amount of bond. It is a bond that I think takes into consideration that if someone can't make that amount of bond, that they should not be released. A bond that high takes into consideration the fact that the court was considering Mr. Viel's dangerousness or potential dangerousness to the community at that point. But that was the bond that was set. Again, I want to be clear because there's been a lot of misinformation circulating regarding the state attorney's role in setting bond. I have up on the screen behind me the Florida statute that pertains to bond. If you could go back. It's found in statute 907.047, and this is the pretrial detention and release statute. And that explains that bond is preferred to be set non-monetary. That is based on the Florida statute, not a law that I created. And that when someone poses a risk of danger to the community, that monetary conditions may be imposed that reflect that individual's potential dangerousness to the community. And again, I believe that's why the court in this case chose to set such a high bond amount, that is an unusually high bond amount of $125,000, which Mr. Viel ultimately made several weeks later. Now, I've said many times before, it's really important to understand that when incidents like this happen, community wants answers. And it is natural to want to find out who's at fault for why this incident took place. But it is important to understand that the only individual who can be blamed for incidents like these is the individual who took those actions. The perpetrator of these horrific events, that's the person who's to blame. And as a community, we need to understand the process, what goes into the criminal legal process. The question is asked again and again, why was this individual out on the streets? In this and many other cases. And it's important to understand that there is a criminal process that predates this state attorney that regulates how the criminal legal system deals with individuals who are accused of committing offenses. That individuals have a constitutional right to be considered innocent until proven guilty, that is a process that takes place from arrest through pretrial, through an actual trial or resolution of the case. And that process is several months, sometimes even years long. And that is a function of our imperfect criminal legal system, but doesn't weigh on the shoulders of any particular agency. So at this time, I'll open the floor for any questions, but I want to end by saying today is a sad day for our community. We have witnessed yet another tragic incident of gun violence, and our thoughts and prayers remain with the two Orlando Police Department officers who made a sacrifice. They made a sacrifice for this community, and we honor them, and we continue to pray for them and their families and for the Orlando Police Department in this difficult time.
Ms. Worrell, the prosecutors during that first appearance could have argued that this girl was 14, that he was a danger, and asked the judge for no bond, no, or say he's on probation, he shouldn't be out. Isn't that part of the role of the prosecutor's office to make some of those arguments to the judge?
So again, whether or not someone gets released on bond is in the discretion of the court, and bond is a right. It is not something that the state gets to decide or not decide. Bond is a constitutional right that every individual receives based on the Constitution.
But you can argue it, that you would like a no bond.
We can certainly make arguments. Ultimately, it is the decision of the court. And in this case, the court determined that $125,000 bond was appropriate.
I am trying to get answers from the Florida Department of Corrections, but in the absence of those answers right now, you had mentioned that Mr. Viel was on probation out of Georgia as of February 2022, which predated the sexual battery arrest. What is your understanding of what Florida Department of Corrections may have done to try to get him violated on his probation when he was arrested for the sex battery?
So again, I don't want to engage in finger pointing and blame. all of our agencies are doing the very best that they can to handle a lot of cases with very limited resources. So I don't want to look back and say what they could have done differently. I think that's a question that is best suited for them. All I can explain to you are the facts, and that is that he did have a warrant that would have resulted in his extradition. But understand that he had 3 warrants, and we just could not get him. We could not apprehend him. And ultimately, when officers did come in contact with him, we see the tragic events that ensued thereafter.
Those warrants were after the sex battery and after he fled.
Which one?
You mentioned there were 3 warrants.
Yes. So the warrant from Georgia was issued in May. The sexual battery was alleged to have happened in March. And the violation of probation warrant was June 16th. And the fleeing and attempting to elude was signed on July 6th out of an incident that took place on June the 30th.
Just to make sure I'm understanding, when you say the Georgia was May, I think you said May 10th, 2023?
Yes,
Which was after the sex battery.
that's correct.
And I guess my question, and I understand why you can't answer it because it's not your agency, but we're just still trying to understand, did FDOC do anything to try to get him violated in Georgia at the time of the sex battery arrest?
Well, he was violated in Georgia, and that's what that Georgia warrant was for. Yeah, he was violated in Georgia, and my understanding is that Georgia would have extradited had he been taken into custody. But what's important to understand here is that until Saturday morning, he was never taken into custody. So all of these warrants would have been served upon him had he been taken into custody at that time, but he was not.
And forgive me for, I know it's not your, but I just want to make sure we understand this correctly. He was arrested for the sex battery in March 2023.
Correct.
He bonded out in April 2023.
Correct.
But he was not violated for the Georgia offenses until
May.
And
Correct.
so it's a reasonable question for us to have of that 2 months and what may have happened.
Yes.
Was he wearing an ankle monitor?
That's my understanding, was that he was on ankle monitor upon his release, and that ankle monitor was cut off, is what I'm being told.
Is there any talks on continuing with that program? Is that with efficiency with that program? Is that common?
That's outside my wheelhouse, really.
For the probation violation that was on the books when he was arrested for the sex battery, how does your prosecutor get notified that might be something to bring up for the judge? Is that the arresting agency? Is that the system?
So it's important to understand that for the probation that he was on here in the state of Florida, that sex battery predated his probation here in the state of Florida. So we were not able to violate him on that because the actual offense that would have violated him happened before he was placed on probation here in Florida.
But that was argued after, according to the court documents, that was argued after that first appearance, not during the first appearance. Did your office already know that? Is that why they didn't fight harder for that violation of probation or to keep him?
I can't speak to when we knew, but I can tell you that the notes that I've reviewed in preparation for this conference today show me that the event that would have violated him took place prior to him being placed on probation. Therefore, we could not violate him on an event that took place prior to him being placed on probation.
This morning, the police chief spoke with us and said that he was pretty bothered by the fact that he was able to get out on bond with a lengthy criminal history. Do you have any response to, the chief saying that he's a little disappointed that he was able to get out on bond?
Yeah, I mean, listen, whenever things like this happen, we're always going to have hindsight and we're going to look backwards. But it's important to understand that bond is a function of the law, right? So as much as we say, well, why did this person get out? We also have to look at the fact that these rules are set in place so that when people are accused, they have a right to be innocent until proven guilty, and that is a process. And as a society, we've determined that we don't hold people in custody while we go through that process. So that's a function of the law. Here at the state attorney's office, we uphold the law, and that's why in this case, this individual was able to get a bond because as a matter of law, they were entitled to receive one.
To the community, what would be your message to them? Because obviously you're right. There were a lot of people particularly commenting on various news articles, social media, what have you, saying this guy shouldn't have had the opportunity to shoot those officers. He should have been in jail. What's your message to the community on that topic?
Our criminal legal system is an imperfect one. And had he gone through the trial process and been found guilty, then he would have been held accountable. And based on the charges that I see before me, it's very likely that he would have been sentenced to a period of incarceration. Now, I want to be really clear. I said, based on the information that I have before me, because while we can hear facts of a particular case on a television and determine that, oh, that person is guilty, that's not how the law works. In the court of law, we base it on facts. We don't base it on opinions. We don't base it on news reports. We base it on facts. So those facts would have had to go through the system, and if they had gone to trial, then a jury of his peers would have had an opportunity to determine whether he was guilty or not guilty, and then he would have been sentenced at that time. So a lot of times we see public figures coming out and making statements about how cases should ultimately be resolved. At the state attorney's office, we can never do that, because the system guarantees individuals the right to be innocent until proven guilty. No matter how bad they may be, each citizen in this country has a right to be innocent until proven guilty. And it is not until the time in which either a guilty verdict is entered or a guilty determination is made by a jury that we then go to what happens next. So the reason that this and any other individual who's out on bond and then commits a crime is out is because that's what the Constitution allows. This isn't something that was made by my administration. It's not a law or a policy that I've instituted. It is something that you will find in this jurisdiction as well as any other jurisdiction across this state, that an individual who is arrested for an offense is entitled to a bond. And in this case, he received one and made that bond.
And to follow up, the law sets what the bond is going to be, what the bond schedule is, and then the court has to either decide whether they're going to go with that bond schedule or elevate it because of, prior bad acts. The law also doesn't allow that judge to predict future bad acts, right?
That's really important, and thank you for that, because a lot of these questions and comments are based on us having some sort of a crystal ball so that we can determine that this individual is going to do something bad in the future or this one isn't. And I know that we only come together when someone does do something, but I want to tell you that there are thousands of individuals who get out on bond every single day who don't commit horrific acts such as this one. And those are the individuals who are, benefiting from what the Constitution says, that you are innocent until you're proven guilty. And sure, when individuals like this one go out and do what he did, we say, well, we don't want that. We want to keep people in. But this is one out of thousands of cases. We processed 55,000 cases in this office last year alone. This is one of them, and this is terrible. But like I said earlier, it's not about who's to blame. It's not about who dropped the ball. Our system is imperfect, and sometimes things like this will happen. And to our victims, it doesn't matter, because we all have a right to feel safe. And all of us collectively do everything we can to ensure that that will be the case. But as I've said many times before, the state attorney's office in particular cannot stop crime from happening. We can only respond once it has happened. And in this case, unfortunately, we did not have the process come full circle in a timely manner that we could have, had this individual taken off the streets.
And I know you say you don't want to point fingers, but
you want me to.
Do you feel, do you wish that either Department of Corrections or Georgia had taken the initiative quicker to seek the probation violation before Mr. Viel was released from custody on the sex battery case? They could have.
Listen,
potentially.
Hindsight is 20/20, right? There's any number of things that can be done on any given day that could make an outcome be different. In this case, those things weren't done, and here we are today. Thankfully, those officers today are alive, and I pray that that will continue to be the case, and that they will continue to be alive and well and recover fully. I'm thankful for that, and I think we should all be thankful for that. And instead of looking at who didn't do what, we've really got to focus on gun violence in our community, because that's the problem. The problem is the amount of weapons that are on these streets and what happens when they get into the hands of the wrong people. And that's what we continue to stand here and talk about month after month after month. An individual had a weapon that they shouldn't have had, and bad things happened as a result. And that is a continuing theme.
Could you have filed a pretrial motion for detention for that sex battery case?
I think that's the same question you've asked, and I've answered it. We could have done any million number of things, but this individual, as a matter of law, was entitled to a bond, and the judge in this situation made a determination that a $125,000 bond was sufficient.
But what I asked is why you guys didn't argue if you thought he was dangerous.
And I've answered that.
You didn't say why you didn't.
And I've answered that we could have done any number of things, but in this situation, the court made a determination.
How much do you know?
I wanted to ask if you could also respond, because you mentioned the FOP in the beginning and some of the things they said, and I was looking at a post that they put on Facebook where they largely seem to blame you for this and sort of say that you sort of, quote, let him walk the streets, and that this is a soft on crime stance. Do you have a response to the way the FOP is framing how this happened and what the reality of the law is?
You know, I think it's terrible when any party uses a tragedy to exploit a political narrative, right? There are officers that are currently fighting for their lives, and I think that it's a terrible thing that the FOP would use this as an opportunity to exploit a political narrative about me being soft on crime. As I've, I think said repeatedly throughout this conversation, bond is something that individuals are entitled to as a matter of law. In this case, the court determined that this individual was entitled to a bond. It was a bondable offense, and the court determined that this individual was entitled to a bond. Now, I know it's helpful to push a particular narrative to say, well, this is the state attorney, but I have a newsflash. I don't have the keys to the jail. I don't determine who gets out of jail. All I do is uphold the law. And in this case, this individual was entitled to a bond as a matter of law, and the court, in their discretion, determined that a $125,000 bond was sufficient.
Are you able to speak to the process that's supposed to happen when a person does cut off their ankle monitor, from your experience as a prosecutor?
So, again, this would have been a reason for them to take him into custody, but there were so many reasons for them to take him into custody. And please understand, when someone is in violation of the law and they need to be taken into custody, all law enforcement can do is try to find them. All they can do is try to find them so that they can exercise their authority to take them into custody. And in this case, we see how tragically that ended, because this was obviously a very dangerous individual. And when law enforcement tried to take him into custody, they ended up being harmed as a result of that. But all of these were reasons that he would have been eligible.
All right, thank you, everyone. The graphic that you see up front